Hey everybody, welcome to Lawyer Live with Matt the Lawyer. I am Matt the Lawyer, Matt Johnston. Before we get started with today's little topic, I do want to remind everybody there's a little link on my website, www.mattthelawyer.com, where you can purchase my ebook on contracts. So today's subject is actually, believe it or not, about contracts. I know, shocking. I've had occasion over the past couple of days to deal with a couple of ideas that really bother me as an attorney and as a client service provider. And they both stem from the same idea. So yesterday I was reviewing a contract for a client, and it's a relatively simple transaction. My client is an advertising agency. They're hiring out a video production firm to create a video for a client, a promotional video. Relatively simple, straightforward job. And the video production company sends them a contract which, in addition to being flat out wrong on the law, was overly complex and probably doesn't really reflect how the parties themselves, my client and the video production company, how they are actually going to operate. Then I was speaking with another client today at lunch, and she noted to me that a real estate attorney that I had referred her to. I don't really deal well with real estate in terms of buying and selling real estate. It's just not an area of my specialty. So I had referred her out, and my client had gotten wonderful advice from this attorney that I referred her to. It was fantastic. The relationship is going quite well, but my client is very disappointed in the work product, largely because the contract that she received from my colleague was very long, very complex, not really geared towards the transaction that was involved. And it got me thinking, how many contracts are written, drafted, signed, negotiated, the whole works, and yet the parties to the contract don't actually operate the way the contract writes? I have often told my clients or told people that I'm speaking to, it is far better to have no contract, no written contract between the parties than to have a written contract that everybody ignores. Because if there's ever a dispute, the only place that people can look is, here's the contract. Now, if you're not really following the contract, you have to prove that the actual contract, the actual relationship was a little bit different. And what if there's a mismatch? What if it's mixed up? What if we follow the contract sometimes and don't follow the contract other times? How does that work? So a couple of the problems that create, or a couple of the issues that create this problem that my clients were facing is, number one, the lawyers who are responsible for drafting these contracts are not thinking about the audience of the contract. Many lawyers assume that the other party also has an attorney, and that may or may not be the case. Now, in the case of my ad agency client, of course, I'm their attorney and I'm reviewing these things for them. It's part of what I do. But not all the time is that the case. Some of the time, the clients or that my ad agency works for, they don't have, their clients don't have lawyers on retainer. They don't have lawyers available to review and deal with questions of legality, questions of understanding what the contract is, questions of whether or not the subject matter is actually accurate. Then you have a different scenario because lawyers, we suffer from what is called the curse of knowledge. We can't really fathom that people don't understand the law like we understand the law. It's a function of our training and education, and we as a profession kind of hold ourselves out as generally better educated than the average person. The problem is not all of our clients are lawyers. Not all of our clients' customers are lawyers or represented by lawyers. So we need to really think about the audience. And if you are a small business owner and you're reading this, or listening to this rather, to this video, I really want you to encourage you to start dealing with your lawyers in terms of, that's not how my clients are going to understand it. My clients don't understand all of this legalese that's in this contract. I don't want them to have to understand it. I want us me and my customers to have an understanding, to know where we are, how we're going to operate, and what we're going to do between us. Because it's far better to follow the contract that everybody understands than to sign a contract that nobody understands and nobody follows. I really would like to hear from folks on this particular topic. How many times do you sign a contract, or do you negotiate a contract with another party, then you hire lawyers to put it together, and you're reading the contract and you don't understand it? It's not clear on the terms. How often does that happen? Because I suspect that it happens far more than it doesn't, and that is a particular problem. It creates a distrust between the parties, because now either the parties themselves are worried that the other side's lawyers are trying to screw them over, I hope not, or a particular party is not sure that their lawyer understands their needs and what they want, which is an even deeper problem for me as an attorney. I need to understand what my customers want, and I need my customers to understand that I am there to advance their interests, that I am there to make their life better, make their life easier, to secure the contracts and the customers that they want. So please send a comment, send an email, complain, rant, whatever you want to do about how your lawyer is not paying attention to how you want, or how you have these contracts that you don't understand but you sign them because you need it, and whether or not you actually follow those contracts. I really would be interested to know. In the meantime, this is Matt the Lawyer signing off. I hope everybody has a great day. Go out and watch some live soccer. Thanks a lot. Bye-bye.